Hello friends, hello professionals, and welcome back to my channel, The Sea of Regulation. Simone here, and I'm back with a video to kind of help some of you out that may be shooting yourself in the foot and putting your foot in your mouth when you're subject to a regulatory inspection. But before I dive in, let me get my usual disclaimers out of the way. I am a financial services regulator, but I'm not a lawyer, and I'm not a professional advisor. And I'm just here to have a discussion about some of the things that I think could help. The views definitely don't reflect that of any regulatory authority or international standard setting body. Now with that out of the way, let's dive in. In this video, we're going to be looking at some of the things that licensees do that actually harm and not help them during their on-site inspection. Now, there are a few things that I've seen from my experience, and without giving away anything confidential, there are some things that I've seen that are really painful. And I think the first one that stands out for me is when the regulator comes a-knocking and we are having that management meeting, virtual or otherwise, dependent on the circumstances. You are sitting there, and this is the board of directors, but your compliance officer is clueless because you've left them out of the loop. That is one of the biggest red flags. That compliance officer is supposed to be essentially on the hip of the CEO and the chairman of the board in terms of ensuring that they have full sight and knowledge and information as it relates to the business's activities. How else can compliance do their job if they're not involved? That is one of the biggest red flags, and it automatically sets a regulator, at least this one. It sets me and all of my red flags up, all the warning signs, the hazard signs are going off, because the person who is supposed to be administering the compliance function doesn't seem to be fully involved. So that's the first red flag that I've seen, and that's the first thing that licensees get wrong in terms of preparing for an on-site inspection. The second thing I've seen that licensees get wrong in relation to on-site inspections is not providing enough information or providing too much. So here's the issue. A regulator will ask you for X, and you provide a ream of paper or you provide one sentence. Either one is probably wrong. If it is that we're asking for certain submissions, the licensee is supposed to be sufficiently knowledgeable about regulation, what we're coming to check, to provide a comprehensive response that is sufficiently comprehensive to address all of the issues, but concise enough to demonstrate that they appreciate what they need to cover and just give the information that is valuable. Now, this may seem like a game that is being played by some entities when they do the data dump. They basically vomit out information and say, let the regulator sift and figure it out. The responsibility is not on the regulator to figure it out. This is you representing yourself to the regulator to demonstrate compliance, and wasting anybody's time is not helpful. And in addition, I've seen that particular trick backfiring, where a lot of information is provided, and guess what? There's something in there that you either didn't realize or you didn't expect the regulator to see, and we've picked up, and then we start tweezing out that particular issue because it's a matter of non-compliance. So I would say to you, be careful in terms of what you put out. It's important to know and strike that balance in terms of providing sufficient information that is concise but gets the job done and answers the questions that are being posed. The next issue that I've seen, and this is issue number 3, is that you play hard to get in terms of even sending the information, and that shouldn't happen. Now, in 99% of regulated jurisdictions, there is a requirement on the books to have licensees be in a position to provide information in a timely manner. In some jurisdictions, they say immediately. In other jurisdictions, they say within 24 hours. Some are lenient enough to say 72. But for all intents and purposes, you're supposed to be able to provide that information that is being requested without delay. If you are playing hard to get, because in some areas you do have the information but you don't want to hand it over, and it's not for the regulator to figure out which one it is. But if you are playing hard to get with the information and not providing it, it may be that that actually comes up against you, because record keeping is a big deal, and having proper records is also a big deal. So you want to make sure that when a regulator asks for something, you provide it. If there's any issue that needs clarification, it is important for you to immediately seek that clarification. It's not for you to think, well, this is what they meant and I'm going to provide that. No. Regulators try their best to be clear, but remember, we're humans, we're not Cylons. We have to make sure that we get the message across, and if there's some miscommunication, it's your inspection report, it's your resulting action, if any. I'm not saying that there's enforcement action in every inspection, but these are some of the consequences that could happen when you have that particular stumble. Another area where I've seen some challenges is with introduced relationships, relying on third parties. Now, as it relates to FATF, that is specifically captured under Recommendation 17. But in relation to the actual conduct of business, it is permitted, but there's certain provisions that you must adhere to. So if you're relying on a third party to carry out that due diligence on the underlying persons for you, no problem. You just need to make sure you hold the information. And in a lot of cases, prior to the update of FATF recommendations in 2012, you didn't have to hold that information. You could just rely on that and ask for that information when you needed it. And you needed to test to make sure that you would be able to get that information without delay. Now again, some jurisdictions are lenient and will give you 72 hours or 24, because 24 is determined to be a reasonable time frame. But in a number of cases where you've relied on third parties, you're not able to get that information when the regulator comes knocking. And that actually goes against you. You've not checked to see that you have actually, your third party is not in jail. These are things that have happened, not to me, not in any jurisdiction I'm familiar with, but it happens and you read about it where an accountant in one particular jurisdiction I'm thinking about, if I can find the article, I'll link it in the description below, was arrested. They were an introducer. And guess what? All of the companies that were relying on that particular professional to provide due diligence information suddenly had a problem. So again, that is an area that you need to assess and make sure works, or address your mind as to how you are going to go forward with that. Another issue that I've seen in relation to inspections is at the point of the issuance of the report. Now, draft reports can be issued, and the draft reports are typically provided for you to address your mind to statements of fact. It's not for you to be a wordsmith. It's not for you to be a book critic. It's for you to look at the information that is being provided and make sure it reflects factually the information that was at hand. It is at this point that some licensees realize that all the other games that they were playing are now being captured and memorialized in a report that will probably not go down well if they were naughty, if they were doing bad things, if they were playing games. And then they try to engage in a process towards rewriting the report. That never ends well. And it doesn't necessarily frustrate the regulator, because it's not for the regulator to accept your editorial comments. It is for you to address your mind to statements of facts and to provide that information in relation to just that component. And once the inspection is completed and a report has been issued, the last issue that I've seen that licensees have real challenges with is in relation to remediating corrective actions. So remediating, another pretty word for correcting the things that were wrong. Licensees are then, in some instances, really negligent and say, you know what, I'll get around to that when I want to. And they don't correct the information. I will give you one of my tips as a regulator. This is what I do. If I inspect you and I've looked at those 10 files, know that some sample of that 10 files is going to be in my next inspection. And if I see that you've not corrected the things that I've identified before in that sample, so a sample of the sample, remember I was an auditor, if I've seen that you've not addressed your mind to that, what do you think is going to happen in relation to enforcement action? what do you think is going to happen in relation to, I don't know, whether you have conditions put on your license? There are a lot of things that can happen because licensees don't take that step seriously. And where enforcement action includes administrative penalties, I've seen licensees pay that and think of it as a cost of doing business. Again, that is not the best course of action. Because of a lot of licensees doing exactly that, I am seeing regulators now looking to take action against the people, because the shareholders are the ones that take the hit for an administrative penalty. But if you in your personal capacity are removed or censured or subject to your own regulatory action, and yes, regulators can fine people, what does that do for your professional career and your reputation? And that is part of why regulators are now shifting their focus towards corporate governance. But guys, if you can think of anything else in relation to inspections and what has gone wrong, definitely drop it in the comments below or send me an email, because you might not want that in the comments below. But if you found this video valuable, definitely hit the like button. And if you haven't, please subscribe. Come on, it helps. And share with your friends. Even if they're not in financial services, I think having an awareness of some of the challenges that licensees have can serve others well, because guess what? We're all subject to oversight by somebody. So you could probably pull a few lessons from this. At least that's what I hope. So guys, I'm gonna end it here and I'll catch you on the next one.